What's up, everybody? And welcome back. We're talking about a new case today. And whenever we introduce a new case, it's always interesting to hear your initial thoughts. I have a poll question that we're going to ask in this video at some point. We are going to give some of the background, but also look forward to an upcoming trial, a trial that has actually started. They have started picking a jury in South Florida for Scot Peterson, who was the resource officer, the law enforcement officer on campus at the Stoneman Douglas School in Parkland. We broke down the trial of the shooter, the death penalty phase trial, which ended up coming back with a controversial verdict of life and not death, life in prison and not the death penalty. This is kind of a continuation of those facts, but it is going to be a very different case. And to give you just some insight about how this case touches other things that we've discussed, there are going to be aspects of this case that are going to be compared to the Nicholas Cruz trial. We're going to compare aspects of this case to the Crumbly parents, to Aiden Fucci's mom, that people involved when their kids do something, or people involved in school shootings that are not the actual school shooters, people that could have or should have done something to stop it and didn't. Those are all going to be connections. The Uvalde case and the Nashville case of how law enforcement should or should not, based on different examples we have, respond to school shootings. So all of that is going to be touched on as we discuss this case. To me, there are things happening in this case that are unusual, that maybe the first time they've ever happened, at least in Florida, that certain things are going to be applied to a law enforcement officer in the situation that Scot Peterson was in. There's also some unfortunate touches on politics that we are going to try to avoid the political conversation and just look at it from a legal angle, because I do think there's also some connections to the George Floyd case and those officers and their actions, because there was some negligence there by some of the other non-Chauvin officers, but it's also different charges, not civil rights violations. It's very different. So to me, there's going to be a lot of cases that we're going to reference throughout the discussion of this case. But on today's video, we are going to read through a summary of the probable cause affidavit. So the facts basically put forward in his charging document. We are going to talk about the charges themselves, what he is charged with, why they might be kind of a stretch potentially. We are also going to watch Scot Peterson, who went on, I think, Good Morning America, or gave some media interviews. We're going to read some quotes. We're going to hear from him, because again, anything that defendants say can and probably will be used against them in a court of law. And then we are also going to watch a video by Law and Crime that was posted, I think, yesterday, where they interviewed Scot Peterson's defense lawyer, who is trying the case right now for Scot Peterson. And it is basically a little tease and a look into what we can expect to hear throughout this trial, or at least what some of the closing arguments are going to sound like. And I want to get into the case a little bit before we ask the poll question. People are asking about this shirt. So yeah, a little more toned down Lawyer merch today. I do love this shirt, the way that it fits. It's one of the longer shirts that has the, I don't know, kind of circular bottom. When they first started coming out with these shirts, I called them the Justin Bieber shirts when I made fun of them, but now I kind of like them. They're a little bit longer. This material is incredibly soft. So it's on the merch site as well. And I think we're going to post the link to it if we can. Some people are also asking about the membership discounted merch. It should be on the site. It is not right now. There should be certain select items that do have a discount on them for a members only code. We're working on that. That will be up shortly. But let's jump into this video topic specifically. Hit that like button if you haven't already, because again, this is a brand new topic. Algorithm's probably not going to pick it up. People are probably not going to know this video is out there for a while. So if you hit the like button, it really helps with that. And if you are interested in this case and are going to stick around for this case, hit that subscribe button. We're on the road to 250K, but I want to make sure that people that want this information, because so many people reached out on Twitter at Tragos Law and Instagram asking me about this case. Will you cover this case? I was like, we already did some of the Parkland stuff. It's tough. I don't want to rehash a lot of that. But this case was really intriguing to me in the different things that are happening, some things I haven't really seen before and I'll just start off from the jump. I'm not so sure that all of this is legally appropriate. I don't know where I stand. I'm not thinking, oh, this is totally horrible. The prosecutors are overreaching, but I also am definitely not in the mind space to think that this is a slam dunk, absolutely how we should handle it in our country. And I think that's going to be the big question I have for you all, the potential jurors, the citizens of America and other countries, is what duties do our officers have? Human resource or school officers, whatever you want to call them, the officers on campus. It's a very sad, horrible tragedy that happened. Nicholas Cruz, some people think, was not punished enough. Some people think was punished appropriately. They think that life in prison is actually worse than death. We're not going to rehash that. But when discussing additional people that are responsible for what happened, Scot Peterson is going to make us answer tough questions and discuss this stuff together as a community. Because Cheryl, you're exactly right. This could and probably will set a precedent for future cases. Now, every case is going to be a specific set of facts and circumstances. We've got a lot to get to, though, so let's get to it. I'm going to start out by bringing up here just the summary, probable cause summary, to kind of give us an idea of what we're looking at. All right. As determined in the above delineated facts, on February 14th, Scot Ralph Peterson was employed by the Broward County Sheriff's Office as a school resource officer assigned to the Marjorie Stoneman Douglas High School in Parkland, Florida. As a member of the Broward County Sheriff's Office, Deputy Peterson had received many hours of training in the proper response to an active shooter situation, and furthermore had received additional training as a school resource officer in the proper response to an active shooter situation in a school setting as discussed above. So that's very important. The fact that he has this training, he is an officer, he knew or should have known what to do in this situation. That's the important part. The facts also determine that on February 14, 2018, Nicholas Cruz entered the 1200 building on the campus of Marjorie Stoneman Douglas High School, armed with a Smith & Wesson M&P 15 rifle. Cruz shot 34 people, killing 17 and wounding another 17. The facts further established that Deputy Scot Peterson was aware that Nicholas Cruz was inside the 1200 building. So they're saying in this probable cause affidavit that he was aware that Nicholas Cruz was inside the 1200 building at MSD while he was positioned between 700 and 800 buildings. Deputy Peterson, as a school resource officer, was assigned the duty and responsibility of protecting Marjorie Stoneman Douglas High School and its occupants. So he had a duty to protect them, including the students of a minor age, and therefore was responsible for the welfare and safety of the MSD students inside the 1200 building during the time the active shooter was firing his weapon inside the building. Deputy Peterson knowingly and willingly failed to act pursuant to his law enforcement training. So knowingly and willingly. So he knew what he was doing was wrong and it was willful. He chose to fail to act. Okay, because failure to act and not doing something, some people say there is a problem with that. Some people are saying there's not. So his law enforcement training and sworn duties directed him to promptly address the active shooter within the 1200 building. Instead, he retreated to a position of increased personal safety, calling him a coward, no doubt about it, and selfish. And furthermore, Deputy Peterson failed to make a reasonable effort to protect the below-listed children from the abuse, neglect, or exploitation by another person by. So the reason you're hearing this language, we're going to read the actual statute of the charges later, but he failed to make a reasonable effort to protect the below-listed children from neglect, abuse, or exploitation. Okay? Doesn't quite sound right, and we'll talk about that more later, but they're using this abuse. They were not neglected or exploited. Were they abused? I mean, they were obviously fatally injured, but it's just interesting, and we'll talk about why in a little bit. So he did that by, 1, failing, declining, or refusing to attempt to investigate the source of the gunshots fired within a building described as the 1200 building at MSD. So first, how did he neglect them and cause these injuries? By failing, declining, or refusing to even try to figure out where the shots were coming from. And or two, fleeing approximately 75 feet from the building described as the 1200 building to the northeast corner of the building described as 700 building at MSD and remaining there during the entire incident. And or three, failing, declining, or refusing to move toward the sound of the gunfire. And or four, failing, declining, or refusing to seek out, confront, or engage the shooter. During the time Deputy Peterson remained between 700 and 800 buildings, crews continued to actively shoot inside the 1200 building, subsequently shot and killed multiple people. And then here are the names that are blotted out. So that's part number one. And I'm going to answer a couple of your questions, but I want to say, after reading that, we're going to think about this case objectively. We're going to talk about this case legally. We're going to talk about what each side is trying to prove. I know the defense doesn't have to prove anything, but what they are going to try to explain and show as evidence and what they're going to try to poke holes in and pick apart. And we're going to discuss whether or not it's appropriate that an officer even get charged or potentially convicted with this, okay? But while we discuss that, well, keep in mind an overarching theme throughout the entirety of this case. What happened that day was tragic. What happened that day was a crime. Nicholas Cruz committed heinous acts for which he's been legally punished for. And Deputy Scot Peterson failed these students. He screwed up. He did not save them. And that is also tragic. But is his failure, even if you want to call him selfish, even if you want to call him a coward, I'm not going to call him those names on stream like this. But even if that failure is true, what would make it rise to the level of a crime? That's what we're thinking about, okay? That is the big question. So we can't get clouded by how we look at him and say, I would have done this different. I would have put my life on the line for those kids, especially if I was an officer. And any of you that have kids in the chat, I mean, you would want somebody to literally throw their body in front of your children. I would want the same thing. I would like to think I would do that in this situation. So I see some people saying, so he is an officer. He did have a gun. This is the officer that they accused of hiding. He's 60 years old, Azam, just for some background questions. So I think most of us are going to be on the same page about this. I really do think most of us are going to be on the same page about the overarching theme. But we are still going to try and figure out if this crime and these charges are appropriate, okay? So stick with me for that, because I need you guys here. I need you all to talk me through this, tell me what the people think, and whether or not, we like to get into sometimes as lawyers into the weeds about, no, this doesn't apply here, that doesn't apply here, this isn't what it's meant for. But you all help to see what would a jury decide potentially on these kinds of crimes. All right, so people are asking, what are the charges? Let's get to them. So, counts 1, 2, 3, 4, 5, 6, and 7 are neglect of a child on or about February 14, 2018. Scot Peterson willfully or by culpable negligence as a caregiver. That's important, as a caregiver. And that's something that's why I want to tell you guys, there's things I have never seen happen in Florida before. I have never seen a law enforcement officer categorized as a caregiver. Teachers, people that are actually at-home caregivers of somebody, parents, as a caregiver. So can an officer be a caregiver? I think that's going to be part of the interesting conversation. Unlawfully and feloniously neglect a child, and in doing so, they blotted out the names, in doing so caused great bodily harm, permanent disability, or permanent disfigurement to said child. No argument about that great bodily harm was what happened to these children, but did his negligence cause that? That's going to be a big question to kind of go through this as well. If he would have charged Nicholas Cruz, if he would have followed his training, would anything have changed? That's a question we're going to have to think about as well. So, this neglect of a child, why did they choose this? Because this seems kind of weird. Caregiver, is this a reach? Well, let's look at the actual statute here together. Let me see if I can pull the right one here. I'm just going to have to get lucky. Nope, I did not pick the right one. So this is the other one. So we'll hold on that. That'll be up in a second. All right. So this is if you know, I have these all up on my screen, but they're not all showing at once, obviously. So this is Florida Statute 827.03. That's what we're looking at here, 827.03. But we're going to scroll down here to, I had it. Here we go. Neglect of a child means a caregiver's failure. We're right here. We're reading this. A caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of the child, or a caregiver's failure to make reasonable effort to protect a child from abuse, neglect, or exploitation by another person. So Brooklyn Basement said, I wonder why they chose the word caregiver when an officer's job is clear enough. Well, we're going to get to that. And I believe it is because this is a felony. This is a felony. And in order to get up, I think it's a second-degree felony. And in order to charge him with a felony, this is how they got there, by calling him a caregiver. Because if we hop back now to the actual charges and we look at counts 8 through 10, it's culpable negligence. Culpable negligence says that Scott Peterson did on or about February 14th, then and there, commit an act or acts which exhibited a reckless indifference to or grossly careless disregard for others and did expose the child to personal injury. I personally feel much more comfortable with this charge, that he exhibited reckless indifference or gross carelessness. This one I feel like I can get behind more, but this is a misdemeanor. This is a misdemeanor. And again, I have it here so we can just take a look at it together real quick. Whoever, through culpable negligence, exposes another person to personal injury commits a misdemeanor of the second degree. And if we want to see this, these are the punishments to second degree misdemeanors. We can go through this on kind of another video. So we're talking misdemeanors where, you know, basically you can get a year in jail versus felonies where we're thinking 15, 20. A first degree felony is life. So that's why the different charges. That's why the caregiver status, in my opinion, because they wanted to get felony charges here. For a caregiver to expose somebody to abuse, to me, is just like, that is not what it's for, right? Like that I'll just tell you, I don't believe, as someone who has written laws in Florida and I shouldn't say written laws, helped write and edit laws in Florida. That's tough for me. I do not think they contemplated officers being included there. All right. Let me get to a few questions here. Gerda, what a good end to my day, celebrating my 50th birthday today and ending it with the Lawyer You Know family. Gerda, happy birthday, a half a century. That's awesome. Thanks for being with us. A Tribute for You, LLC. Finally caught a live stream. Love your channel. Thank you so much. Net Woman, all officers are trained after Columbine. Definitely derelict of duties should have charges. So I think now's the time, John. Let's go ahead and post the poll. So do you think at this point, as you sit here, after we've read the charges and the probable cause affidavit, do you think it's appropriate just that the charges are being brought? Would you say there's probable cause for these specific charges? Not guilty or not guilty on the crimes, or not at trial yet? Not what I'm asking yet. Poll is live. Beth, PO, do the police officers do the best they can in chaos of the situation at the time, even with training. The world these days always wants someone to blame, someone to pay. Strong, unjustified words in that charge. So it's good. I think back to back, we have a difference of opinion, which I think is perfect timing for the poll to go live. The poll to go live. John, did he have the proper resources to engage the shooter? Body armor, high power ammunition, etc. So this is one of the arguments actually from his lawyers, that he did not have what he needed to go up against somebody that had an AR-15, that had an assault rifle. He did have a weapon. More on that later. What is the definition? This is from the Lily Dragon. What is the definition of neglect? You have a duty, you breach that duty, and your breach of duty causation is important, the damages. So he has a duty as a police officer. I don't think anybody doubts that. And there were damages to these kids. Nobody is going to doubt that. Did he breach his duty is one of the main questions. 4 elements. It looks like 5 the way I'm doing it. Did he breach his duty? What should he have done in those circumstances based on what he had, like John said? And then even did his breach, if he did run and hide or whatever they're accusing him of, did it actually cause the damages to these children? Those are going to be big questions. Brooklyn Basement, shameless super chat asking Peter to wish me happy birthday. Happy birthday, Brooklyn Basement. My daughter, Brooklyn, is in New York today with my parents, her and her cousin, on a girls' trip to start summer. They're so pumped. Joe Lyons, I'm struggling with this. Only one person chose to kill, trained or not. Who knows how we'd react? There's so many overarching themes and questions to this. Like, we want good people to be officers, right? At schools and otherwise. We don't want just people that are going to be overly aggressive and go overboard. We want some people that think, but we don't want people to run and hide. I'm not saying that's what he did, but we don't want people to run and hide in the line of duty when our children need protecting. These are hard questions. There's no easy answer. So don't take anything I say as, oh, Peter thinks he has the answer. This is so easy. No, hard questions on both sides. We don't want overly aggressive law enforcement officers that are going and looking to just pound anything they see in front of them. But we don't want people that are too passive. We want good, level-headed, trained, and willing to act and do the things normal citizens cannot or will not do in the toughest of situations. But how do we get there? And is criminal stuff like this, is that going to help us or hurt us? Caitlin, I think this gets into proving someone's mindset / decision-making process during an emergency, which is a slippery slope. And that's why first responders have immunity in a lot of these situations. So I agree with you. That is another huge question, Caitlin. That's why I think this case is really important to talk about. I do. So I hope you guys are interested in it, because I got a lot of questions on it before I even really looked into it any deeper on Twitter and Instagram. Part of the oath, in other words, but would a jury find him negligent for care of a child, like a parental responsibility? That's what it sounds like. Who's my neighbor? U.S. Supreme Court has also ruled that police have no specific obligation to protect. 1989 decision, DeShaney v. Winnebago. It's to enforce the laws or whatever, right? I think that's what that case says. Yeah, but again, we've already seen this start to change. Crumbly parents, Floyd officers, there are ways to find around when somebody does something wrong, and I don't mean Chauvin, I mean the other officers, when somebody does something wrong, or when somebody does something that you should step up and try to do something about and you don't, we are getting more and more likely for criminal prosecution in those situations. Taylor, did he do the exposing of abuse to these kids? That's the point. Did he? That's one of the questions. And we're going to hear from his lawyer. I got to get there, though. There's just so much to talk about. Cyan, he neglected his duty to protect. If he hadn't have hid, even if he saved only one life, that would have made all the difference to that person's family. Very sad case and not clear cut. I agree with you 100%. Let's not jump and show that he just hid yet, because I think there is going to be a lot of evidence and information coming out in this trial that we may not know yet. John O'Rourke, didn't the officer think there were multiple shooters as well? Great question. So at this point, let's go ahead and jump to, let me see what's next on my list here. Let's jump to first a statement by FDLE when the arrest was made for Florida Department of Law Enforcement. We're going to read that, and then we're going to jump right into an interview that Scot Peterson gave, I think, on Good Morning America. Following an investigation by FDLE, former Broward County Sheriff's Deputy Scot Peterson was arrested today on 7 counts of neglect of a child and 3 counts of culpable negligence and 1 count of perjury. Oh yeah, I forgot to read. There was a perjury count. I'm not 100% positive what that's about, so we'll dig into that more later. The arrest comes after a 15-month investigation into the actions of law enforcement following the MSD high school shooting. The FDLE investigation shows former Deputy Peterson did absolutely nothing to mitigate the MSD shooting that killed 17 children, teachers, and staff and injured 17 others. The FDLE commissioner said there can be no excuse for his complete inaction and no question that his inaction cost lives. So here's where I'd like to pop in and say, this is why each case will be different. Because when officers try, when they do something, even if they fail, they can point to it and say, that's different than this. And again, we don't know all the facts, and I'm waiting till the trial to get the facts, but what the allegations are is he did nothing. He hid. He was scared. He should have done something. So you can differentiate it from other cases if they, in fact, do something. All right, let's finish the statement here. I was pleased the Florida Department of Law Enforcement, in conjunction with the state attorney's office, conducted a thorough investigation that yielded the arrest of Scot Peterson. All the facts related to Mr. Peterson's failure to act during the MSD massacre clearly warranted both termination of employment and criminal charges. It's never too late for accountability and justice, Sheriff Gregory Toney said. The case was investigated by Broward County State Attorney's Office. Peterson was the school resource officer during the shooting. I'm trying to think if there's anything else. Here we go. During the investigation, FDLE agents interviewed 184 witnesses, reviewed countless hours of video surveillance, and wrote 212 investigative reports totaling over 800 hours on the case to determine the actions of law enforcement as they responded to the February 14th shooting. FDLE agents received a full cooperation and assistance from the Broward County Sheriff's Office, Coral Springs PD, and all other agencies that responded to the shooting. Peterson was arrested. All right. I wanted to show that because it shows no love lost. Law enforcement's against this guy. At least the FDLE is at this point. All right. Let's get into his Good Morning America interview here.
Now to more of our exclusive interview with Scot Peterson, the armed resource officer on duty during the Parkland school shooting.
That's probably a little too fast for you guys, right? We'll go 1.5. We have a lot to get through, so I apologize. If you hate the 1.5, you can always slow it down on your stream.
On Tuesday, he shared his moment-by-moment account of what happened that day. Well, today we pick up the story when he found out he was being forced to resign and later would be accused of being a coward.
It's still a bit fast, so let's knock it down one more.
It was surreal. It was like I didn't know what was going on. It was a shock to me.
They never said, hey, explain your actions here. We have a few questions.
No, nothing. Because I know I didn't violate any policy or procedure. I've been with the agency 32 years. I know the policies. I know the procedures. I communicated right on that scene. I did everything that I felt at the time was appropriate.
So, big words by Scot Peterson. I know I did nothing to violate any policies or procedures. That might come back to bite him. if they in fact can show you did violate policies and procedures. Always dangerous to do these interviews.
You cannot violate policy and procedures and still not get it right.
You're right. You're absolutely right.
Is that what happened here?
Exactly. Exactly. I mean, like I said, Savannah, this will haunt me the rest of my life. It will. Because my kid, those were my kids. So, and that's why it hurts the way it does.
8 days after the
He is obviously apologetic and miserable and hurt about this, but he also admits he did not get it right. And that's what this jury is going to have to sift through. Is not getting it right automatically a crime? Or like he said, can you follow the policies and procedures and still have a horrific result, but it still not be criminal? This is a huge, huge question and a huge case, I think. I really think, I don't know if you guys are going to be as interested as some other ones, but this is one that could be groundbreaking to me.
Parkland shooting. It would be Scot Peterson's last day as a police officer, but he didn't know why until this.
And he never went in.
The captain was driving me home, and my phone started, going off saying that, Sheriff Israel is basically, ripping you apart. People started to text me.
What matters is that when we in law enforcement arrive at an active shooter, we go in and address the target. And that's what should have been done.
He said you did nothing when you clearly knew there was a shooter inside. He said you clearly knew based on what he had seen.
It's not true. It's untrue.
Joe DeRusso is Scot Peterson's attorney.
I don't think a crime scene that's that big, with that many witnesses, with that many people injured, that you could have completed a full investigation within 8 days. I don't think it's possible.
He waited and he didn't want to go into the school.
President Trump weighed in. Did you hear what he said?
Part of it. And, President Trump, the only thing I can think is he went on the false narrative of Sheriff Scott Israel. But you know what? We are living in a free country. I mean, it just hurts. That's the commander in chief. That's, that's the president. It's tough. I have 2 kids in the military. It's tough. My boys.
This man standing outside of the school the other day doesn't love the children.
The president said he thought a school resource officer doesn't love the kids. That's what he said.
He doesn't know. He wasn't there. It's easy to make comments and say things, in Washington, D.C. You weren't there. You didn't know what I believed and what I said and what I heard those first few minutes on that scene. I think it was just easy for them to make me, the punching bag.
This is one of the worst things that's ever happened. One of the worst school shootings. And you're getting blamed for not stopping it.
If I knew everything, I would have been in there and engaging that shooter. And you know what? Hopefully I would have shot him. He might have shot me. I don't know the what ifs, but it's been hard. I mean, but it's nothing compared to what these families went through. They lost their kids, and kids were killed and injured. They lost them. I'm alive. I mean, going through what I went through, it's horrifying because as a police officer, if you're a coward, that's the worst label you can have as a police officer. And it's not true.
Since the shooting, Peterson says he's been leaning on his faith and his family, a fiance and 4 grown children.
What have your kids said to you?
They're all adults, but they support me. I mean, I told them everything what happened, and they support me.
When we first started talking, you said, in a way, you wish you could have opportunity to talk to the families.
Mm-hmm.
In a way, I guess this is sort of that opportunity.
It is.
What would you want to say to them?
I'm sorry. I'm sorry that I didn't. I'm sorry that I didn't know where he was, or it was one person. I didn't know who it was or where they were initially. And it's tough. It's tough. And knowing what I know now, it makes it even tougher because I know about active shooters. It's not like I have no knowledge, like what can happen. It's just I didn't believe when I first got there that that's what was going on. And like I said, it's going to haunt me the rest of my life.
What's he going to do now? What's the rest of his life going to look like?
Well,
So he says there, I know what to do, an active shooter. I know what to do. I'm sorry. I wish I could have known where he was, who he was, what he was doing. Again, making those statements and other media statements were referenced here again in the probable cause affidavit for the search warrants where it says media interviews by Scot Peterson. The Washington Post published an article with the headline, "It was my job and I didn't find him. He remains haunted by the massacre." The article documented an interview reportedly conducted by Mr. Saslow with Deputy Peterson. The majority of the information provided in the article summarized Peterson's reassertions of the statements he made to the BSO detectives during his sworn interview on February 16th. Per the article, He discussed other aspects of the incident not covered by the detectives, to include his reaction and actions during the MSD incident. In the article, it is reported that he told the interviewer he remembered reacting in those first seconds by doing what he believed he had been trained to do, taking cover in a tactical position so he could clear the area. He leaned his back against the wall of an adjacent building. He took out his gun and scanned the surrounding palm trees, the courtyard, the windows, the parking lot, and the roof. It's haunting, Peterson said. I've cut that day up 1,000 ways with a million different what if scenarios, but the bottom line is I was there to protect and I lost 17. Per the article, Deputy Peterson reasserted the statement to the BCO detectives that I only remember hearing 2 or 3 shots. He said, I know there were more, but that's all I heard. If I heard more shots, I might have known where to find him. If I knew where he was, I could have gone in. So again, a lot of ifs and a lot of these statements are going to be used against him. If I could have come in over here, I could have got him while I was reloading. If I just heard more shots, maybe I would have known where they were coming from. Then he went on the Today Show and he said he thought there was a sniper involved because I believe there was a sniper. So in my mind, I'm thinking to myself, there's possibly maybe somebody up there shooting out, but I didn't think they were shooting at the kids. I thought they were shooting out at the building outside. He also informed the Today Show interviewer that it just never even dawned on me those initial first few minutes because I never believed there was even an active shooter inside. He said, what I was trained is you contain the area and I have my gun out and I'm scanning and I'm looking, and that's what we're trained to do. When you get a position and cover it, we are trained to scan and look. During the conclusion, he said, I'm sorry that I didn't know where he was, or it was one person, or I didn't know who it was, or where they were initially, and it's tough. And knowing what I know now makes it even tougher because I knew about active shooters. It's not like I have no knowledge, like what can happen. It's just I didn't believe when I first got there, that's what was going on. So more statements that he makes. And again, interesting, strange to go on and make these statements and do these interviews. Cyan said the policies and procedures of the school don't match the law. Does that open the school up to a lawsuit for neglect? Yes, the school, not just this. There's a lot of things that can open the school up to neglect for a civil suit, including what this officer did. That can be negligence. He was a Broward County employee, could be their negligence. For civil suits, there's tons of civil liability here. But we're talking specifically criminal. And anybody's policies and procedures, if you're trying to prove negligence, you can use. Saying this is the law, these are the additional policies and procedures. If you disregarded them and then bad stuff happened, that could be negligence or even willful negligence. But I think it's really important to always show both sides. That's what the point of a trial is. We've listened a lot to what FDLE had to see, the probable cause affidavits, the allegations, what he's charged with. Let's take a few minutes. It's 29 minutes. I'm going to put it on 1.5 speed. We'll get through as much as we can before I have to jump off of here. But let's watch this interview done by Law and Crime. I thought it was a good interview, asked some good questions, and got a lot of information from the defense lawyer who's going to be trying the case representing Scot Peterson. So let's listen into what he had to say.
All right, let's talk about the trial of Scot Peterson. Not that Scot Peterson. I'm talking about the former sheriff's deputy school resource officer who has been charged with 7 counts of child neglect and 3 counts of culpable negligence for the 10 people that were shot, including 6 killed during the Parkland school shooting back in 2018. The allegation being that Peterson did not enter the building with his service weapon and confront the shooter. Now, I should tell you that Peterson is not charged with respect to the 11 people that were killed and 13 people that were injured before he got to the building. Now, with this trial about to begin, I want to bring on a very special guest.
So they did differentiate from the timing of when he actually got there. So he is not charged in all of the people that were injured or fatally wounded in the shooting just after he got there. And that's where they're saying his negligence caused those additional people to get injured and killed, because if he would have done what he's supposed to do, he would have stopped the additional injuries. So he obviously couldn't have done anything before he got there. But once he got there, that's where the charges started.
Guest, a familiar face for all of our Law and Crime trial watchers, Peterson's criminal defense attorney, Mark Eiglarsh. Mark, it's so good to see you. Thanks for coming on.
I appreciate you having me, Jesse.
So let's do a broad overview. Okay. So my understanding is the defense's main argument is that your client is not criminally responsible because he did not know where the shots were coming from. He did not know the shots were coming from inside the school. Is that correct?
If we had to sum it up in one soundbite, then I guess I would agree with that. There is so much more to this because the situation was very fluid, right? The 4 minutes and 15 seconds that he was there while the shooter was there for 6 minutes and 36 seconds, each shots changed to some extent, but all remain the same in that he did not know precisely where the shots were coming from.
Okay, let's talk about that. Now, you're very kind. You shared some trial boards with me, and I think this one is particularly helpful. What it is it actually shows the time frame. So we're talking about 6 minutes and 36 seconds when the shooter was in that school. So we're talking about 2:23:25 p.m. to 2:27:35 p.m. And your client was on the scene for the final 4 minutes and 15 seconds. And I want to be clear. You're saying during that entire time, he thought the shots were outside?
I will answer it this way. He had no idea with certainty that the shots were coming from inside the 1200 building and or that any kids were killed at all. And it's important to note, people say, well, he was there for so long. Again, his only opportunity to kill the killer was 4 minutes and 15 seconds. So the clock starts to run the minute he hears the first shots when he arrives on scene. He had a 32-year career where he was an exemplary officer. He's the father of 4 children, 2 who served in the military. He won numerous awards, Deputy of the Year, School Resource Officer of the Year. And we're talking as recent as 2016 was the last award he received. So just 2 years before this atrocious massacre that took the lives of so many, he was decorated. So all of a sudden they're claiming.
And I love how this lawyer continues to say and doesn't shy away from this was a horrific massacre. What happened that day was horrible. He mentions a couple times in this interview that, listen, when he first saw it, he was like, screw this guy. Or he didn't use those words, but he was like, I didn't like it. I hated this or I hated that. And I think he does kind of show a little bit of that he's a real person and he's a human being throughout this interview, which I think makes it more compelling personally.
He became some coward, some criminal. I say absolutely not, Jesse.
Why did he think the shots weren't coming from the school, inside the school, or wasn't sure they're coming from inside the school? Because I would imagine a counter argument could be, well, why didn't he just open the door, gun drawn, and listen to what's going on?
Got it. There's a reason why we're asking the judge to bring the jurors to the scene. It wasn't until I got there that I literally said out loud, are you kidding me? I told the prosecutor, I go, get over here. Like almost like he was keeping this from me. The building is nothing like you can imagine. It is 73 yards long from one end to the other. We're talking about 3/4 of a football field, and it's very high. You can't imagine how big it is. My client was investigating a firecracker complaint on the east side of the building. So he starts to approach the door. He never got to the door. He never opened the door because boom, shots were fired on the entire other side of the building. At 2:23:25, my client hears the loudest boom. And the reason why he thought it was coming from outside, along with 20 some odd other people that we will have testify who also thought it was coming from outside, is because the door was opened on the west side of the building where the shots were coming from. The shooter was aiming his gun in a westerly direction, and Aaron Feist, the coach, was on the other side of the door. So the door's open, the shots are going out. It sounded like it was coming from outside. Every single witness, even the most right-wing state witnesses, say it was very reasonable for my client to believe from hearing those initial shots that they were coming from outside and not from inside the building.
So taking that as true, I guess a counter argument would be,
so again, where are the shots coming from? Is it even an active shooter? Is it inside? Is it outside? What information did Scot Peterson have that he was acting upon? Those are really important questions. Newbie, what is the actual job title and description? And Connie said, but is it normal for for an active shooter, normal to go for an active shooter alone as a police officer? These are the questions that I think experts are going to have to answer for us. And it's going to have to be presented for the jury during the trial to make this, to get this answer, to come to the conclusion, to determine what happened. Yeah, Melisasi, I thought that was kind of weird too, but we'll just gloss over it.
well, how come he didn't get closer to where he thought the shots were? You know, there's surveillance video of your client on the outside of the building. And people have criticized your client because it appears that he's just standing there or pacing back and forth. And I guess the argument would be, why didn't he try to go closer to where the shots were and make any kind of movement? Because there'd be a difference if he was behind, let's say, a car or behind some sort of structure, taking fire, looking out. He was just standing there.
Right. Okay. So great question. I thought that too. As a citizen in South Florida, where I initially thought, my goodness, what a coward. I don't even want to meet with the guy. All right, fine. He wants me to represent him. I'll meet with him reluctantly. And then he showed me the evidence. Okay. And I don't know that we're ever going to accomplish in 20, 30 minutes the totality of what is the evidence. My opening statement will probably be an hour and a half, 2 hours. Okay. But I will try to break it down in sound.
His opening statement is going to be an hour and a half, 2 hours. They have so much evidence. Dare I say a mountain of evidence, as we've heard many times in many different cases, a mountain of evidence. So to me, I think the defense is going to have a lot. And he said, I don't even want to meet with the guy. Okay, he wants me to represent him. Fine, I'll talk to him. But I think he's a coward. That's what he said before he met with Scot Peterson and saw the evidence in the case. That's compelling to me. Now, we've heard people say there's a mountain of evidence in other trials and come up with squadoosh. So we'll see if this guy and Scott Peterson actually have all the evidence. Because again, defense doesn't have to present the evidence, but now I'm expecting the evidence because he is going on television or broadcast or whatever, YouTube, and telling the world they have evidence. They are going to present evidence. So I think that's going to be really important for me. People are saying they really like this guy. They usually don't like defense attorneys, but they like this guy. I think because he's showing he's a human being. And he's like, I thought he was a coward and I didn't want to represent him. And then when I saw what he had, I was like, wow. And that can happen. And like I said, when you believe your client, it really can make a huge difference. And you should only take cases, obviously, that you believe your client.
Okay. At some point, he got as close as he could to where he thought the sounds were coming from. He announces on his police radio immediately, shots fired, 1200 building. Now, he says that because that's the general area from where he's hearing the shots. He doesn't know, as again, 20 some odd other people that will be testifying. If you start running to the right, you have no idea. You run to the left, you have no idea. You start running forward, you don't know. Could the shots be coming from the top of the building, the east side of the building, the west side of the building, the 1300 building, the parking lot? If you saw it on the map, you'd see literally everything was in play. So what he did was what his training told him to do. You eagerly await for more information. If you don't know where to go, you're waiting. And guess what? People are saying he knew because they would have told him over the radio. No, all those calls that the children made from inside the building on their cell phones went to Coral Springs Police Department and not the Broward Sheriff's Office. My client's with the Broward Sheriff's Office. So all those calls, and this is undisputed, went to Coral Springs Police Department. Nobody hatched the radios. No one ever told my client in real time, hey, listen, go into the 1200 building. The guy's on the second floor or the third floor. So to answer your question, no, he didn't know. And by the way, I'll add this. The scene becomes fluid. At some point, my client believes, almost right away, because the Las Vegas shooting took place just a few months before, if I don't know where the shots are coming from, I may be the target of those shots. He's thinking almost right away, and he told the investigators this right after the shooting. He thought potentially he's dealing with sniper fire. And the next round of shots are literally whizzing over his head. So you don't stand out and go, okay, all right, except you're on a cheat.
So, and that also matches up with some of his media interviews that he did. Beth asked, is the defense lawyer saying too much before the trial? This is why it's great to have a good lawyer. If they go on, can they say too much? Yes. But most of the time, when we've broken down what lawyers have said and things like this, it's calculated, and he may be trying to balance the narrative. Not that he's a coward, not that the evidence is stacked against them, but instead they're going to come out on the offensive. They have evidence. They're going to prove it. Listen to all these holes in the state's case. This is not appropriate. Shouldn't be done like this. That's what he's trying to do. Which to me, I think he's doing a good job. Okay, but I'm still going to wait, regardless of what this guy says. He's also raising the bar a little bit for me of what I expect out of the defense's case. But I think he's doing a great job, personally. And somebody asked, what's the Webster's definition of squadouche? Zip, zilch, nada. That's what I would say, or next to nothing. That would be the Webster's definition.
Cheesy TV drama involving cops. That's when you stand up with no
I'm going to back it up again because he gives kind of an
potentially
example of what people actually expect to happen versus what happens in real life.
Next round of shots are literally whizzing over his head. So you don't stand out and go, okay, all right, except you're on a cheesy TV drama involving cops. That's when you stand up with no vest, no helmet, no nothing, a little gun. No, you take a tactical position of cover and you wait for these bullets to stop whizzing over your head, and or you know it's safe to come out. It was never safe for him to come out.
Just to follow up on that, he doesn't appear to crouch, though. He's standing.
You'll see that there's a pole that blocks what he's doing.
Yeah,
all witnesses say that he was in a position of cover with his gun. He was looking. What you see is him going forward. And I asked him about that. I go, yeah, it looks like he said, Mark, the radios are so bad in that building. And everybody will say how bad the radios are, even before the shooting. You get no reception inside the school. He was forced to leave his position of cover, take a few steps so that he can get any reception and or be able to have his messages received. And I sent you a certain transcript of what he was saying in real time. And boy, was he getting information out.
That's exactly what I want to go to. So you sent this trial board of the transmissions. I'd like to go through them with you if we can. So,
and just so we're clear, these are only his transmissions.
Yes.
Very telling also are the transmissions that were made of other officers, like when the shooter's in the building, Deputy Kratz yells, shots fired from the football field. Shots fired from the football field. That gets repeated. As my client's trying to figure out where this is happening, he's hearing shots fired from the football field. Another person gets on. Shots fired middle glades.
So I'm saying, this guy is convincing me, if nothing else, we have to have an open mind going into this trial. What evidence is the state going to present? Is it going to line up with those charges we just read? Or is the defense going to create and show a completely chaotic situation that regardless of the policies and procedures, this guy was never going to do anything to stop it? He didn't know where to go or what to do based on the information he was given.
Middle glades, that school is all the way hundreds of yards west. It was impossible to discern precisely where the shots were coming from.
By the way, before we get to the transmissions, just to be clear about this as well, is your client the only one who's been criminally charged for not doing something?
Yes.
And why do you
And
think
just
that
so we're clear, there were, I'm going to tell you, numerous other officers who heard the same shots my client did, didn't know where they were coming from, and didn't go in the building, right? So yeah, I think it's selective prosecution. Here's what happened, okay? I don't mind going public with this because I'm going to say it in the trial, but I'll get some backlash. The chief, Sheriff Israel, very well known around here, politician, okay? He was taking heat because that's what they do. Right or wrong, it starts at the top, right? What's wrong with your men? Why didn't they do better? Couldn't this guy have been stopped? And I'm not saying whether he could have done better or not, but you know, hell, if it's bad weather or gas prices go up, the person at the top always gets blamed. So he was taking a lot of heat. So we went on Jake Tapper's CNN, the town hall meeting, and he got crucified. I mean, nobody was favorable towards him. He admitted that to me in deposition. So without calling my client, and he had my client's cell phone because that deputy worked at the school football. He was a football coach, and his sons went to that school. So we had a very personal relationship with my client. Instead of calling my client to say, hey, buddy, tell me what happened. I need to know, why didn't you go in? That wouldn't have worked for him because my client would have told him what I'm telling you now and how he couldn't tell and the echo, the pronounced echo in the area that everybody talks about. He then does that famous press conference where he says, he should have gone in to kill the killer. And I remember hearing that myself as a citizen. I'm going, wait, so he knew where the shots were coming from based upon that? He knew kids were being harmed and he just chose to cower in the corner and do nothing? That was the...
So there he goes. He mentioned it again. I really like that he's doing this. He says, as a citizen, I heard this and I'm like, this guy knew where they were and did nothing. He didn't go inside and try to do anything. He just cowered. He was a coward and he cowered behind something, hiding, protecting himself. So he knows what the citizens and what the jurors are, their preconceived notions may be because he had some of them himself. And he knows how to combat them. I think that's really important. And that's what I want from you guys. And I'm hearing it from you guys in the chat. And it seems like if the jury is anything like the chat, it's going to be tough to win on at least the felony charges. And after 1,000 votes, should he have even been charged? 56% of you said yes. 44% of you said no, that he should not have even been charged, that there wasn't even probable cause enough for this crime to be connected to this person. So the state has an uphill battle in this case, I think, which is always interesting when a trial like that starts, when the state actually has an uphill battle.
Narrative that he tried to sell us because that gets all the heat off of him. He ultimately then was suspended and fired, and they came after him. Eventually, the governor got him. But once everybody hears that, oh my God, it's a political firestorm. The governor then has the Florida Department of Law Enforcement investigate my client. And it wasn't to find a neutral finding. It was, you better take that guy down. The victims' families, they were outraged, as they should be, that a guy did nothing. And then the prosecutor was given half of the information, distorted information. I have the reports that were handed to the prosecutor. The lead investigator, Riddick, will be crucified by me. He left out, amongst other things, my client asking in real...
The lead investigator, Rick, will be crucified by me. The prosecutor's only given half of the... I mean, he is making some very bold and serious claims that, again, I mean, I think he wants people to watch this trial. I think he does. I think he wants people to learn the truth. This reminds me a little bit of that popcorn shooting case here, also in Florida, where the attorneys came on my channel and talked about it afterwards, about how the media just got it wrong. They weren't given all the evidence. And once the jury was given all the evidence in the law, it was clear.
Time to one of his officers, hey, do you know where the shooter is? You know where the shooter is? He left that out. Doesn't that evidence that in real time he doesn't know where the shooter is? How dare he say that he left it out because, well, the shooter was gone at that point. I said, wait, the shooter was gone for a minute and a half and no one on the scene knew that. So you don't think that still evidences his state of mind? No, I don't think it needed to be included. Garbage in, garbage out. Between the political pressure and the fact that this investigator left off key information, like my client ordering a code red, which is what he did for the benefit of all those kids, my client got charged. It was no surprise.
And look, from my point of view, I think there's a difference between trials being fought in the court of law, which is where I think it should be, and all the facts come out, versus the court of public opinion, because there really has been a very strong public message against your client, and I know that he's looking forward to clearing his name in this trial. So I'm curious.
And that's exactly what this lawyer is trying to combat here, in my opinion.
See how this is going to play out. I do want to go back to the transmissions, though, because I think this is important. So again, these are the transmissions from your client. Let's go to 2:23:26 p.m. Be advised, we have possible, could be firecrackers. I think we have shots fired, possible shots fired, 1200 building. Then I'm going to play another one, 2:24:14 p.m. We're talking about the 1200 building. It's going to be the building off of Holmberg Road. So when he says that, and he's talking about the 1200 building, couldn't someone interpret that as him saying it's happening inside the building? The reason I say that is because how come in those transmissions he doesn't say it's coming from outside the 1200, it's outside that building? How come he doesn't say that?
All valid points. I think if I'm being intellectually honest with you, I say, yeah, when he says 1200 building, boy, that could be interpreted. One way someone could interpret it as he's now somehow giving intelligence as to where the shots are specifically coming from. But that's just not the truth. What he's doing is he's giving the quickest location where he's at. That first transmission, he's literally hearing shots as he's on the east side of the 1200 building. And he wants the cavalry to come. So he's saying 1200 building. He's not saying, by the way, I hear shots from within the 1200 building, because I'm sure that from 73 yards away, with the door opened up and the shots being fired in an opposite direction from where he is, I know with certainty that the shots are coming from inside the building. So I get it. I understand that's enough to give the prosecutor a good faith basis to go forward and say, aha, he said 1200 building. When officers are trained to give their location, he does believe that the area around the 1200 building or the neighboring 1300 building, which he then says later on in the transcript, is where the shots are coming from.
So to me, this is something that I think the jury's going to have to decide based on what he's saying about the 1200 building. I'm sure we're going to hear those recordings throughout the trial. Based on what he's saying, should he have known, or did he know, did he show based on what he's saying that he knew the shots were coming from in there and still do nothing? Or based on what his lawyer is saying, was he just basically saying where he was and trying to get the cavalry there?
Okay. So him saying 1200 building will be the feature of the state's case. And I'll say, yeah, he's giving his location, 1200 building.
And I think a text message, not a text, excuse me, a transmission that might be helpful to that is at 225:18, where he says, we're looking at the 1200 building. It's going to be the 300 building, going to be off Holmberg Road, the senior lot. Is that, when he says the senior lot, is that him saying, I think the shots are coming from the parking lot?
No.
So it sounds like he's going to make this case political. I'm just telling you, I'm being 100% honest. I'm not a very political person, as you guys know that. I try to stay out of it. I believe what I believe and think what I think. And we talk about a lot of it here without, putting any political labels on it. I don't even know which side wants what. Honestly, when I look at this case and they say it's political, I don't know which side wants what. I mean, I saw a very outspoken president from one side condemn this guy. So does that just tell me what side everybody's on? I don't really get it. And I don't really know. So I'm just going to be, this ain't going to be political on this channel. I'll just put it that way. Susan, not necessarily. I think I give a lot of credit to jurors in these situations. I think the caregiver thing is going to be tough to prove to a jury. And then I think causation, to prove that to a jury may be tough. I think the jury is the right one to make this call, honestly. You give the judge a chance when you try to dismiss these claims like they've done multiple times, and the judge has not dismissed them. So if the judge really thought that this was squadouche, they would have dismissed the charges. Belinda, we'll see. Maybe we can make it happen. A lot of merch requests, which is always fun.
I'd love to see that interpretation. No, to be honest with you, no.
Hey, I was trying to help the case. That's the way that I looked at it.
I loved it. Now I'm thinking, should I use that? But no, because it's not the truth. He's just trying to narrow down for everybody to find the location of where he's at, where the scene is at. Nobody knows that school, so he's trying to give it a description. But keep going with these transcriptions, because you're going to then see a lot that supports my client's belief that he is.
Did you hear what he just said there? I want to point it out real quick. I like to give lawyers credit when I can. He said, wow, that was a good point. Maybe I'll use it. He said, but I'm not going to, because it's not the truth. And that's the point. Just because you can make an argument, just because you can say something and it may sway the jury, doesn't mean you should as a lawyer. You should go with the truth. And the truth will either set you free, or it will still point to whatever the result is supposed to be. Sometimes it's not good for your client.
Facing potential sniper fire because he's locking the school down for that reason.
And this is the one I really wanted to get into. So this is 2:25:56 p.m. And he is responding, acknowledging Deputy Kratz. And he says, all right, 26. Also heard it's over by inside the 1200 building. We're locking down the school right now. Make sure there's no pedestrian traffic anywhere on Holmberg Road. Is it at that point he knew that the shots were coming from inside? Because didn't the shooter still remain in the building for another 2 minutes?
Yeah, the answer is no. You read that? We would then play the statement. He didn't say by inside the 1200 building. He didn't say it that way, Jess.
I'm just highlighting that word, the fact that he said inside.
It's not lost on me that word appearing there could be something and will be something the state highlights. But what he's saying is by inside, meaning he's struggling. One of the possibilities is he believes that shots may be coming from the 1200 building, meaning he could be under sniper fire at that point from somebody shooting out of the 1200 building, which he was, because at that point, the guy's shooting bullets over his head. He had just done that. So my client believes by inside. He doesn't know if it's inside, by. He's still trying to figure it out. But here's the key. The second part.
These are almost kind of some statements from his client. Again, I think the prosecutor, listen, we're only hearing from one lawyer here. The prosecutor, I think, is going to be able to make a very compelling argument that when he says inside the 1200 building, that he knows or is telling us or letting us know that he knows the shooter is actually inside there. Now, it is later in the process. He's only there for 2 more minutes. It's not the whole 4.5 or 5 minutes or whatever they were arguing from the jump. And we'll see who was actually injured after that next 2 minutes. But there's a lot going on, and the timeline is going to be really important.
That statement, okay? Where he says that we're locking down the school right now. Make sure there's no pedestrian traffic anywhere on Holmberg Road. So now we've got 2 scenarios, and you'll see throughout this transcript, he's locking down the school and people from coming in. This was the time that parents were coming to pick up their kids. He didn't want a flood of people on the scene. Why? Because he's thinking they're going to get killed with these bullets, okay? If he thought, as the state's alleging, that shots were coming from inside the 1200 building, he says, guys, get over here now. Get in. Let's go. He doesn't lock down the building. In fact, he further states in another minute or so, stay at least 500 feet away from not just the 1200 building, but also the 1300 building, the neighboring building, because he fears that sniper fire could be coming from anywhere. And he wants to make sure that nobody comes onto the campus. So You've got two options, Jesse, if you're the jury. Either he is some evil SOB who wanted children to die and keep cops away from helping those kids, which nobody's going to say, or he reasonably believed that he was potentially facing sniper fire and wanted everyone to stay off the campus.
Well, is this prosecution?
So people are asking for another poll. John, why don't you just repost the poll? It was 55% yes, 45% no. So it's pretty close to 50-50, but we'll post another one as we finish the rest of this interview.
Arguing that he's evil or that he was scared?
Well, I haven't heard the prosecution's argument yet.
Right.
Maybe it was scared. I don't know. I hope they say scared, because in the worst case scenario, you're talking about a cop who's human and froze, but that's not what happened.
So is the prosecution arguing he's evil or he's scared? That's what Jesse asks. And he said, the lawyer said, I hope they argue scared, because then he shows he's a human being. But I do think scared and neglecting your duties can go wrong, at least under the misdemeanor criminal negligence. Maybe he doesn't care about the misdemeanor charges. Maybe I am sure he will feel like that's a win if it's not guilty on the felony charges and guilty on the misdemeanor charges.
Happened.
Let me ask you one question.
I'm talking about that transmission.
Yeah, I wanted to ask why, and correct me, because I'm sure this is going to come into evidence, could an argument be made, well, if he thought the shots, he didn't know where they were, but maybe thought they were coming from outside, why not enter the school? And is that a tactical advantage? Because you're no longer outside. You're now in the school, and you might be able to see out what's happening. You tell me if that's going to come into evidence during the course of this case.
Probably. Anything is, hindsight is 20/20. But in real time, okay, and you'll hear from 20-something other witnesses, equally plausible are about 20 to 30 other scenarios of where the shooter or shooters might have been. When you think you're under sniper fire, you don't just get up and guess it's going to be in the building. There's a 13. You start maybe in the 1300.
So he just did something there again. Sorry if you guys think I'm pausing it too much. He just said shooter or shooters, because a lot of times when we have to go back in time to try these cases and say what our client was thinking and doing in that moment, we have to remember what our client knew at that moment. What was the scope of his knowledge? He did not know it was one shooter. He didn't know it was a student. He didn't know where he was. He didn't know what his plan was, what he was doing. We know all that now. We've seen the drawings and the writings and the trial and the transcript and the testimony. We've seen all that now, the videos. But back then, he didn't necessarily know all of that. And that's incredibly important to what actions he took and what he should have done. What was his duty?
Building or run to the football field. There, he was told shots fired by the football field. So he wished when he heard that, he gets up and he just runs to the football field. People would say, "Oh, well, why'd you go there?" In other words, he's waiting to be the most tactically serviceable by waiting for some type of real-time intelligence that never came on his radio. He's just waiting. Somebody tell me where to go. So yeah, hindsight's 20. And by the way, let me just add. By the way, just got to add that building. It took a SWAT team. Let's go with your theory. A SWAT team, 30 minutes to clear, and there's a SWAT team of 12 people, armed, tactical gear, to clear the first floor, to then clear the second floor, to then get to the third floor. He supposedly would have had to have gone in there and within 4 minutes and 15 seconds, cleared the first floor, cleared the second floor to get to the third floor. The theory is, well, maybe he would have heard the shots on the third floor.
That's really compelling. SWAT team of 12 people were there. SWAT team, more highly trained than the resource officer. 30 minutes to get to the third floor, clearing each floor. So how in 4 minutes or 5 minutes was he going to clear all these floors by himself? It's pretty compelling.
You know that not a single kid.
And that doesn't mean he wasn't negligent. That doesn't mean he failed to do something. That doesn't mean he wasn't a coward. He could have been all of those things. I'm not saying he is, but allegedly, even if he was all of those things, he never would have been able to do anything to stop the damage. Therefore, his negligence and his cowardice did not cause the damage. That's an argument I think that they can make.
On the third floor, heard the shots from the second or first floor. I can't explain it, but the video shows them calmly walking into the third floor when the fire alarm goes off, and they're all calm. And then Cruz appears on the third floor, and then the kids go crazy. So there's no way he would have heard the shots. If he went in on the first floor, he would have heard shots. He would have to clear every classroom. It would not have made a difference.
You make a very interesting argument when you talk about the transmissions he was receiving weren't very particularly helpful to him. But you said there's 22 witnesses that also thought the shootings might have been happening from outside. I'll ask you, when did they think the shooting was happening outside? Did they ever think that maybe they thought it for the first minute or so and then realized it was inside? And B, my understanding is your client, when the shots first happened, jumps into a cart with 2 unarmed civilian security guards. He tells them eventually to leave. But my understanding is those guards believe the shots were happening inside the school.
Okay. So you asked a bunch of questions. Your first one, I've already forgotten because I'm getting old.
No. So the first one is about the 22 witnesses who say the shots might have been from outside.
So let me
did they ever realize when it was outside? Yeah.
Okay, that's really compelling. And here's the list. I sent it to you, okay? Pick what you like. You like police officers, you like teachers, you like faculty, you like students. They're all on here, all different genders, flavors, colors, whatever you want. No one with any particular loyalty to my client. And in real time, they all believed 100% and never changed, never vacillated, that the shots that they heard were coming from outside of the building. But more specifically, each one mostly gives a specific location. And what's unique is that they're literally all over the place. There's 2 sisters who are testifying, same DNA, same shots heard. One puts the shooter on one side of the campus, the other one puts the shooter on the other side of the campus. They're all over the place. And so to answer your question, no. After the shots were done, they didn't then say, well, gosh, those initial shots I thought were one place, and now I believe otherwise. No, they all felt they were coming from inside the building. And one teacher who I just spoke to yesterday again, okay, she had a student come talk to her and say, I opened up the 1200 building and it looks like there's firecrackers going off in there because there's a lot of smoke and I'm hearing lots of pops. So he thought there were firecrackers in there. He goes and he tells the teacher. She has this real-time intelligence as she's exiting her classroom and getting within 15 to 20 feet from my client. She hears the same shots he did.
Right.
And she said 100% they were coming from outside, and she never changed her mind.
And what about the security guards I thought the report was they thought the shots were coming from inside.
They did. For sure, one of them did. I'm not sure about the other one. For sure, Greenleaf, who was with him. So I asked Greenleaf and Medina, the other two security guards, had extra information. I don't have those exact words, but extra information with Medina having gone to the building and he heard things. So they had extra information that my client didn't have. But
They didn't communicate with him. They didn't communicate with your client.
They 100% did not. Okay. There was some allegation that Medina told my client on the way to the building. Medina says in deposition, 100% that is totally false. I never communicated. Your client was on his radio, listening, monitoring. He was never given that information. But I will tell you this. I did ask Greenleaf, who, by the way, was interviewed after. In other words, everyone was interviewed after they knew the shots were coming from 1200 building. I think that affected certain people, right? But let's say Greenleaf was being honest. He said, no, I thought the shots were coming from inside. Well, did you ever communicate that to my client? Did you ever say, hey, man, go in there. Shots are being fired. He said he never did. I also asked him, did it look like my client knew where the shots were coming from? He said, no. Did it look like my client was trying to struggle and try to figure out where they were coming from? Absolutely. And he describes what led him to conclude that.
I mean, and one thing I can tell you, this lawyer is going to do a really great job of making it seem like chaos and impossible to figure out what was going on, when, where, why, and what he should have done. I think Uvalde was much, and I may be saying that wrong, was much worse than this. So we'll see how this affects that. Nicole, he said the other officers did nothing as well. If true, why aren't they being charged? He said that he thinks his client is basically a scapegoat. There's political things going on. That's basically what he said is his answer. I don't know the answer. Kimmy, doesn't the caregiver logic open the door to teacher faculty being charged in the future since schools have campus-wide policies and procedures and drills? Yes and no. They already are potentially included in the caregiver statute if they allow somebody to be abused in their class or know something and don't do it. That's why they're mandatory reporters a lot of times, but their duty is not to stop an active shooter. So it is a different duty. They wouldn't be charged in these situations. It would be to stop abuse, which is the point of the statute. If you know abuse is happening in your classroom, like your teacher aide is abusing one of your students and you do nothing, you as the teacher can and should be charged with this.
So yes, that's what I give to you on them.
Let me ask you about the trial. It sounds to me like this is an opportunity for your client to take the stand and explain what happened. Is that something we can expect?
There's always an opportunity for that. And I'm going to tell you this, 99% of the time I keep my clients off the witness stand. Number one, anyone can be made to look like they're guilty, even when they're not. Okay, we know that. Prosecutors already bragged to me that he's a skilled cross-examiner, right? So if my client takes—
Prosecutors already bragged to me that he's a skilled cross-examiner, and he just said he's going to destroy or crucify one of the officers. So, lawyers, they like to talk about how great they are at this stuff. So he was asked, is this guy going to testify? Seems like he would. He said, and he's explaining kind of his philosophy on when a criminal defendant testifies. Okay, so let's listen in on kind of his philosophy.
And it's because he has to. And I don't
back it up just a little
Is that
bit.
something we can expect?
There's always an opportunity for that. And I'm going to tell you this, 99% of the time I keep my clients off the witness stand. Number one, anyone can be made to look like they're guilty, even when they're not. Okay, we know that. Prosecutors already bragged to me that he's a skilled cross-examiner, right? So if my client takes a stand, it's because he has to. And I don't think he has to. Now, he might want to. He may insist, Mark, I got to get up there. He's telling me that. He's telling me right now, Mark, they've got to hear from me. I got to get up there. But if he doesn't, I'm telling you right now, it's because I tell him, you don't have to.
That's interesting, right? Letting us behind the curtain a little bit. Attorney-client privilege information, maybe. I probably would not have gone this far. I probably would have just said, we'll see. But this makes for good TV, makes for a good interview. He's telling us his client wants to get on the stand. Again, I think this is all calculated. For you to see and hear his client, for you as lay people, right, to hear his client wants to take the stand, wants to tell the jury he's not guilty, wants to explain to the jury what he's saying, that you're thinking, yes, that's what innocent people do. So he's taking the blame as the lawyer, saying if he doesn't take the stand, it's because I tell him not to. Again, it's smart.
You don't have to let this pit bull of a prosecutor make you look guilty, number one. Number two, it's not going to be necessary. They will not be able to prove this case beyond the exclusion of every reasonable doubt that he did a criminal act. The guy ordered a code red. The guy did everything he could to protect those students with what he had. We'll be able to prove—
I mean, you can't let code red be said 17 times in a criminal case without thinking of a few good men. And I think that he's going to reference it throughout this trial, that code red is what it is. And I'm interested to hear how that gets weaved in.
That with all the things that he did. He ordered a code red, by the way, and one teacher couldn't get back into his classroom because he left his keys in the classroom. Those kids were left to run in the hallway and cruise the killed those kids. My client's being charged with child neglect for those kids. Where does the teacher's responsibility come in?
I'm glad you mentioned that because I want to go into an interesting legal argument that I was hoping you could explain to both me and our listeners. And my understanding is that you want the jurors to hear this Florida statute that specifically excludes law enforcement officers from being labeled as caregivers. Prosecutors have argued that he is a school resource officer. He is a caregiver. I think the judge said that the jurors should be able to decide if that caregiver label will apply to your client. Walk us through what that's about.
Well, an appellate issue clearly is the judge's failure to dismiss this case, which he should have legally, but I understand why he didn't politically, because the statute clearly defines.
So legally, he says he should have dismissed this case based on the caregiver portion, but politically, he understands why he didn't. He is not afraid to say this is all about politics, I guess.
What a caregiver is, and it says excluding law enforcement officers. So the judges went, well, school resource officers are different. No, they're not. They're deputies. They're sworn officers. Additionally, they're not caregivers. Factually, I hate making that argument because, like, well, they do offer protection to the kids, so they're kind of caregivers. But let's look at it in a practical matter. I'm going to ask every single SRO, school resource officer who's testifying, hey, do you feel like you're a caregiver? In other words, do you check on each kid to make sure they're nourished, they had enough water, their needs are cared for? No.
That's why I thought it was important to read that statute and talk about nourishment and food and water and all that stuff, because I think that that's when you all picked it up as lay people. Is this really right? Does this really fit? I'm not so sure. Culpable negligence, I think that should be what this case is about. Was he culpably negligent to a criminal level and causing these injuries? And I think causation is really going to be the big point in that culpable negligence. But the caregiver one is tough for me.
Well, it's because they're not. How about this, Jesse? This image. Picture me playing the role of my client, right? Who's a school resource officer investigating a student for a felony. And he says, I'm going to read your Miranda rights. You have the right to remain silent. Anything you say can and will be used against you. Pause. And when the student's deciding whether to answer, he goes, wait, hold on. Now he moves closer to the student and he says, I'm your caregiver now. Don't answer the questions because they could really harm you. I'm your caregiver. Don't answer that question. He can't play the role of caregiver and police officer.
And I'm just to be clear, the caregiver is just for the child neglect charges, or can it also be applied to the culpable negligence charges? Because I want to understand why this is so important, this label.
Felony.
I'm focusing on the felony charges, the child neglect. No cop has ever been charged under the statute because it's just not legally plausible. It took this unusual set of circumstances. If he's convicted of a misdemeanor, they don't take his pension and he doesn't essentially go to prison for life. You start adding in these felonies, there you go. There's the teeth. That's why it's being done.
Yeah. And that's what we talked about in the beginning as well. The misdemeanor, he's focusing on the felonies because that's how you go to jail for the big time. The misdemeanors would be no big deal. And I guess he can keep his pension with the misdemeanors as well. So that's why it would be a win if they get not guilty on the felonies, even if he's guilty of the misdemeanor culpable negligence charges.
Mark Eiglarsh, my goodness, I'll tell you one thing. You are an incredible attorney. I can't wait to hear these opening statements and hear how this trial
Are we really
progresses.
done?
Unfortunately, I have to wrap up because you've been doing a great job. I asked everything I wanted to ask.
Buddy, okay, here's I'm serious. This isn't like to promote anything. I'm telling you, there is 96% material that we have yet to cover, which is what a trial is for, I guess. You know, you've done an incredible job teasing them, I suppose, because there's so much more. I will leave here going, oh my God, I didn't tell them about this. I didn't tell them about this. Yeah, but there's so much that we didn't discuss. But you did a great job. But in the interest of time, that's all we've got. But there's so much more that would answer these questions more thoroughly.
And look, it's not even teasing our coverage of the trial. Really what it is, I think it's an important case. I really do. In a day and age, when we're talking about the liability of parents of school shooters, when we're talking about if more could have been done. I mean, it's the year anniversary of Uvalde and we're looking back on mistakes that were made there. I think that this is important. And I'm glad we had the opportunity to talk about it for, 30 minutes or so. And I'm going to be looking forward to seeing more of it, Mark.
Well, time flew by. I cannot believe it's 30 minutes. And I will tell you, if you're a cop out there and this becomes precedent, be very careful. I mean, I wouldn't want to be a police officer. Somehow you make a choice. You think that it's a sniper when it's not. You make the wrong choice. You keep people away. And now all of a sudden you're facing a life sentence. It could happen because it's happening to my client.
All right. We will watch and see how it unfolds. Mark Eiglarsh, terrific.
Wild. And again, we'll see if he's able to make those kind of arguments in closing. I don't think he will be, but crazy stuff, man. It's going to be wild. I agree completely that this case is really important. JR, Cruz was on a killing spree. He would have killed SP on the spot, Scot Peterson. SP is lucky to be alive and will forever live in the remorse and regret that he could have done more. Leave the man alone. I think there's going to be a sentiment of that as well. And it's really 50-50 kind of split in how you all feel about this case. So that's what's going to also add to the intrigue of discussing it on this channel. So please, anybody you talk to on Reddit, Discord, whatever, Twitter, Instagram, and they want to discuss it and they're interested in this, point them in our direction, because let's bring more people to the conversation to see if really this is a wider spread. We're not really sure how to feel about this case yet based on the charges. Follow me on Instagram and Twitter at Tragos Law for more discussion. We are going to have to call it. We're over an hour. I've got to get to my next call. I appreciate so much. Everybody that comes in here that spends their time discussing and their energy to help educate us and let us know what people are thinking and what kind of the finger on the pulse is of the community. So I appreciate that so much. Hit that like button on your way out. We will be discussing this case more. They are picking a jury right now. So we're going to see this lawyer more in court. We're going to finish here with Beth. The day is already here where people won't go into LE because of the public nightmare. Sad day. I agree. And we need to try to fix. The pendulum can swing. We can fix this as a society, as a community. And I think if we need to fix it, we need to do what we need to do to fix it, to get good, level-headed, strong people in law enforcement and smart. That's what we need. All right. I am out of here. Until next time, I'll miss you. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.